Welcome again. In this section, we will cover consideration, which is an important element of a contract. Students working on their law degrees are often tested on this topic in their contract law exam. I am going to start our discussion by looking at an example. I promise to drive you to Oxford and you promise to pay me £50. Your promise to pay me £50 involves both a benefit to me and a detriment to you, the two angles of consideration, and is given in return for my promise to drive you, the two sides of a contract. Conversely, my promise to drive you is both a benefit to you and a detriment to me, and is given in return for your promise to pay me. If I drive you to Oxford and you refuse to pay me, I will sue you, and the court will focus on your obligation to pay me, and not on the other side of our contract. When the court looks for consideration in relation to your promise to pay me, I will point to what I have promised in return, that is, promising to drive you to Oxford. What is consideration in this situation? If you pay me in advance and I refuse to drive you, you will sue me, and the court will this time focus on my obligation to drive you and not on the other side of our contract. When the court looks for consideration in relation to this side of the contract, you will point to what you have promised in return, that is, your promise to pay me. Is that consideration? There are separate considerations on each side of the contract, but what counts as consideration in any given contractual dispute will depend on which obligation on which side of the contract the court is asked to enforce, and this will obviously depend on who is suing whom. Currie versus Misa, 1875, Justice Lush said, "A valuable consideration in the sense of law may consist either in some right, interest, profit, or benefit accruing to the party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other." While looking at an issue or case law, it is very important to identify whether the so-called consideration is actually a good or a valid consideration. To do so, you must know the difference between sufficient and legally sufficient consideration. In Chappell Co Limited versus Nestle Co Limited, 1960, defendant ran a promotional offer. In that offer, public could receive a music record by sending off 3 wrappers from the defendant's chocolate bars plus a postal order for 1 shilling and 6 pennies. Defendants manufactured the records for this purpose. Plaintiff, the copyright owners, claimed there had been breaches of their copyright. The issue or the question was, were the wrappers part of the consideration? It was held by the majority that the wrappers were part of the consideration, even though trivial economic value and thrown away by defendants on receipt. There had been a breach of copyright. Now, the wrappers, were they sufficient in your view? Probably not, but they were held to be legally sufficient. It did not matter that the wrappers in themselves were worth very little and did not equal to the market value of the record, even when added to the 7.5 pence. Nestle were free to request whatever they wanted. They obviously hoped to benefit economically from the arrangement out of increased sales of chocolate.